The HOA queen bulldozed my wooden bridge, so I made her pay for a brand new one. I was standing in my backyard, coffee in hand, watching a bulldozer tear through the old wooden bridge that had connected my property to the creek trail for 32 years. A machine I never hired, never authorized, and never even heard coming until the first plank split with a crack that echoed through the whole neighborhood like a gunshot. Patricia Weston, president of the Maplewood Ridge HOA, stood 15 feet away in a cream blazer and pearl earrings, arms crossed, watching the destruction with the calm satisfaction of someone who had already decided the law didn't apply to her. And from the way her attorney stood at her side nodding, she genuinely believed she was untouchable. What neither of them knew was that I'd had a hidden camera on that creek easement for 6 months, that my brother-in-law was a real estate attorney who specialized in property rights, and that the bridge Patricia just destroyed had been registered as a protected historical structure with the county, which meant she had just committed a felony, live on video in front of 2 witnesses. My name is Daniel Mercer, and I moved to Maplewood Ridge, Virginia, 6 years ago with my wife Claire and our 2 kids, Lily and Ben, after years of apartment living in D.C. We wanted a yard, a real neighborhood, a place where the kids could run around and we could breathe, and for a while we actually got exactly that. The house sat on a half-acre lot that backed up to Maplewood Creek, and the old wooden bridge at the edge of our property had been built by the original owners in 1991, a beautiful handcrafted structure with cedar planks and iron railings that crossed a small dry season creek and connected to a trail the whole neighborhood used for decades. Claire and I were both teachers. She taught 5th grade, I taught high school history, and we had saved for 11 years to buy this house, chosen specifically because of that yard, that trail, and that bridge, which the previous owner had mentioned in the listing as a cherished feature of the property and which we'd come to love just as much as they had. Patricia Weston had been HOA president of Maplewood Ridge for 9 years by the time we moved in, and within the first month, 3 separate neighbors pulled me aside independently to warn me about her, not in an alarmist way, just the quiet, weary tone of people who had already learned the hard way that Patricia played by rules she wrote herself. The HOA here wasn't small. Maplewood Ridge had 214 homes, a $4,200 annual fee per household, and a board of 5 members, 4 of whom, I would later learn, were either related to Patricia, employed by her husband's landscaping company, or had been appointed to their seats by Patricia herself during what she called emergency interim elections that somehow never appeared in the official meeting minutes. On the surface, Patricia was the kind of neighbor who brought casseroles to new arrivals, organized the 4th of July block party, and kept an immaculate front yard with seasonal flowers that changed every 8 weeks like clockwork. She was charming, warm, and utterly convincing at the performance of being the community's loving caretaker. But within 6 weeks of moving in, I received my first violation notice. A printed letter on HOA letterhead informing me that my mailbox post was non-conforming in color and that I had 14 days to repaint it or face a $200 fine, which I found baffling since the post had come with the house and was the same beige the seller had used for at least 15 years. I repainted it. 2 weeks later, another notice. This time my garden hose reel was visible from the street and therefore in violation of Section 7.4b of the Community Guidelines, a rule I had to look up because it wasn't in the summary document we'd received at closing, but only in an addendum Patricia had apparently added unilaterally 18 months prior. I asked at the next HOA meeting why the addendum hadn't been distributed to new homeowners, and Patricia smiled at me the way a chess player smiles at someone who doesn't yet realize they've already lost, and said the document was available on the community portal, a website, I soon learned, that required a login she controlled and which hadn't been updated since 2019. My neighbor across the street, a retired firefighter named Gary Okafor, invited me over for beers that same week and laid out 2 years of his own violation history. A manila folder thick with notices, fines, and letters, most of them targeting cosmetic details that weren't violations in the actual CC and RS, but in supplemental policies Patricia had added without a member vote. Gary had fought one fine all the way to the HOA's internal appeals process and won, only to receive a new notice for a different alleged violation on the same property the following month, which he was convinced was retaliatory but couldn't prove, because the board minutes that should have documented the discussion were redacted in ways that Gary's attorney said were deeply unusual. I started paying attention in a way I hadn't before, not defensively but methodically, the way I approach history research, looking for patterns, inconsistencies, the gap between what's written and what's actually practiced, and within 3 months I had a spreadsheet tracking every violation notice issued in the neighborhood over the past 4 years, cross-referenced against the CC and RS. What I found was that violations in Maplewood Ridge were not evenly distributed. They clustered heavily around 8 households, all of which had at some point publicly questioned Patricia at a meeting, filed a formal complaint about HOA governance, or simply declined to volunteer for one of her pet projects, which she referred to as community service commitments. The bridge at the back of my property wasn't technically in the HOA's jurisdiction at all. It sat on a private easement that had been deeded to my property in 1991, and a county records search I ran confirmed it was registered under my name as the current title holder, separate from any common area the HOA managed. But from the beginning, Patricia had a particular fixation on that bridge. She mentioned it at our first HOA orientation meeting in a way that seemed casual but wasn't, noting that it connected to a trail used by all community members, and that the HOA had some interest in its maintenance, which wasn't true legally but was delivered in a tone designed to plant doubt. The trail Patricia referred to was a public greenway maintained by Fairfax County, and while several neighbors did cross my bridge to reach it, they did so informally. There was no easement granting the HOA or any third-party right of access across my private property, a detail I had confirmed with a property attorney before we even made our offer on the house. Still, I didn't push back on the bridge issue early on because it seemed like a peripheral concern. Patricia hadn't cited me for it, hadn't formally claimed any authority over it, and I was focused on managing the steady stream of minor violations she was already generating for other parts of the property. About 8 months after we moved in, Patricia sent a letter on HOA stationery informing me that the board had reviewed the condition of the Mercer property bridge and determined it required safety remediation within 60 days, no inspection, no code citation, no engineer's report, just her assessment and a deadline attached to a threat of fines. I wrote back formally, citing the easement documentation, confirming the bridge was my private property, noting that no HOA representative had the authority to inspect or impose maintenance requirements on private property without my consent, and requesting the specific legal basis she was relying on. I sent it certified mail with return receipt. She never responded to the legal questions. Instead, 2 weeks later, I got a notice that my front porch light fixture was the wrong color temperature, 3000 K instead of the community standard 2700 K. A notice so absurd that even Gary laughed when I showed it to him, but which still required me to buy new bulbs to avoid the fine. That was the dynamic Patricia operated in. Whenever she was challenged on something substantive, she pivoted to something petty, keeping the pressure constant, while avoiding any direct engagement with legal questions she knew she couldn't answer, a strategy designed to exhaust and discourage rather than resolve. Claire, who is far more patient than I am, suggested we try the social route. Attend the HOA social events, be visible and friendly, give Patricia fewer reasons to feel. We were adversarial, and I agreed to try it, not because I believed it would work, but because I wanted to be sure I'd exhausted the good faith options before escalating. For 4 months we attended every event, the spring cookout, the neighborhood watch meeting, the community garden planning session Patricia ran, and during that time the violation notices slowed to a trickle, which I initially read as progress until Gary pointed out that the same thing had happened with him twice, right before things got significantly worse. The twist I didn't see coming. At the community garden planning session, Patricia casually mentioned that the HOA was exploring options for improving creek access for all residents, and that she had been in conversations with the county about easement adjustments. Language that meant nothing to most of the room but made the hair on the back of my neck stand up. I asked directly in the meeting what properties those easement adjustments might affect, and Patricia smiled and said it was still in the exploratory phase, and she'd share more when there was something concrete to share, which was HOA speak for, "I'm doing something I don't want you to know about until it's too late to stop it." That night, I called my brother-in-law Marcus, who had been a real estate and property rights attorney in Northern Virginia for 16 years, and I described what Patricia had said. He was quiet for a moment and then said very carefully, "Dan, I'd pull the county easement records first thing tomorrow and find out what she's actually filed, because exploratory sometimes means already in motion." Marcus was right, of course. When I pulled the county records the next morning, I found that Patricia, acting as HOA president, had submitted a formal petition to the county requesting a public access easement over a 40-foot strip of my backyard, including the bridge citing community trail connectivity as the justification, signed 3 weeks earlier, before the garden meeting where she described it as merely exploratory. I sat with that petition printout for a long time, reading it twice, then a third time. It was precise, legally formatted, and referenced 2 county trail development grants as justification, which told me Patricia hadn't done this impulsively but had planned it carefully, possibly for months, possibly since before we even moved into the house. Marcus came over that Saturday and reviewed everything: the original property deed, the easement documentation, the HOA CC and RS, and Patricia's county petition. And after 2 hours he sat back and said, "She doesn't have a legal leg to stand on, but if she gets the county to act on this before you file a formal objection, it becomes a much harder fight." And he started drafting the objection letter that same afternoon. We filed the objection with Fairfax County's Department of Planning and Zoning within the week, with a full legal brief attached. Marcus did it pro bono because, as he put it, "This is exactly the kind of HOA overreach I've spent a decade fighting, and it makes my blood pressure go up just reading it." Which was reassuring even if it was also alarming. Patricia received a copy of our filing as a matter of public record, and I know the exact moment she read it because 3 days later Claire found a notice tucked under our front door. Not in the mailbox, tucked under the door by hand at some point after midnight, citing us for unauthorized modifications to common area adjacent landscaping, which was the most transparently retaliatory notice yet. I photographed the notice, photographed the landscaping it claimed to cite, and sent both to Marcus with the timestamp from our porch camera, which showed the notice being placed by someone in a light-colored jacket at 11:47 p.m. on a Tuesday. Someone who moved with the confident, purposeful stride of a person who did not expect to be on camera. Marcus advised me to document everything from this point forward, obsessively and in real time. Every notice, every meeting exchange, every conversation with board members, every piece of HOA correspondence, because he said what we were entering now was not a neighborly dispute but a calculated legal campaign, and the documentation would be the weapon that mattered most. I installed 2 additional outdoor cameras, one covering the backyard and the easement, one covering the bridge specifically, and I want to be clear that this wasn't paranoia. Within 48 hours of installation, the backyard camera captured 2 men I didn't recognize walking along the creek bank and stopping at my bridge, taking photographs and measurements with a tape measure. I didn't confront them. I documented them, pulled the footage, and had Marcus send a cease and desist letter to the HOA the next day, citing the unauthorized entry onto private property, and demanding identification of the individuals and the purpose of their visit. The HOA's attorney responded 4 days later, calling it a misunderstanding and offering no identifications. The county responded to our objection filing 6 weeks later with a notice that Patricia's easement petition had been placed on hold pending property owner dispute resolution, which was a partial win. It didn't kill her petition, but it stopped it from moving forward without our participation, and it meant she couldn't quietly get the easement approved while we weren't looking. What it also meant, I realized, was that Patricia now had a problem. She had made a public move, it had been publicly blocked, and she was the kind of person who could not accept a stall without escalating, which meant I needed to be ready for whatever came next and to make sure that whatever it was documented, witnessed, and handled through proper channels. At the next HOA meeting, Patricia announced that the board had voted, in a meeting I was not informed of, that did not appear on the public notice calendar, to commission a structural safety inspection of all private bridges and structures within the Maplewood Ridge community that had trail adjacency, a category that, as far as I could tell, applied to exactly one structure, mine. I raised my hand and asked for the minutes from the meeting at which that vote was taken, the names of the inspectors who had been hired, their credentials, and the legal authority under which the HOA claimed jurisdiction over private property. Patricia looked at me for a long moment and then said the minutes would be made available in due course, which meant never. The inspector showed up at my door unannounced on a Wednesday afternoon. A man named Dale who identified himself as working for Crestview Property Solutions, a company that, when I Googled it that evening, had been registered in Virginia 11 months earlier with Patricia's husband listed as the registered agent and no professional engineering credentials on file. I did not let Dale onto my property. I asked him politely to leave, told him that any inspection of my private property would require my written consent and proper credentials from a licensed structural engineer, handed him a copy of the letter Marcus had prepared for exactly this scenario, and closed the door. He stood on my porch for about 30 seconds before leaving. 2 days later, I received a certified letter from the HOA's attorney stating that by refusing access to the inspector, I was in violation of Section 12.2 of the CC&RS, which granted the HOA right of access to inspect structures that may pose a safety risk to common areas. I forwarded it to Marcus, who read Section 12.2 carefully and pointed out that it applied only to structures on common areas, not private property, and that the HOA's interpretation was, in his words, legally illiterate. Marcus fired back a 3-page response that included the correct interpretation of Section 12.2, a list of the HOA's procedural violations in convening an unnoticed vote, a formal demand for credentials for any inspector they intended to send, and a note that any further unauthorized entry onto our property would result in both a trespass complaint and a civil action. The tone was polite, precise, and lethal. Patricia's response was to do what she always did when cornered on substance. She shifted the battlefield. At the following community meeting, she stood up and delivered what I can only describe as a performance. A carefully worded speech about community safety, responsibility to neighbors, and the importance of cooperative homeowners who put community first, never mentioning me by name but making it crystal clear who she was talking about. Several neighbors who didn't know the full story nodded along, and 2 came to me afterward with the slightly awkward look of people who had absorbed Patricia's framing without examining it, asking if there was something I could do to work something out with the HOA, and I had to explain, carefully and without losing my temper, that what I was being asked to do was surrender legal rights I was entitled to keep. Claire handled those conversations better than I did. She was a teacher. She knew how to deliver difficult information without making people feel stupid for not already having it. And by the end of those conversations, most neighbors were considerably better informed about what Patricia had actually filed with the county and what the bridge dispute was really about. But I noticed something at those meetings that I filed away. 2 board members, a woman named Sandra Chun and a man named Phil Rutherford, were watching Patricia with expressions that weren't quite supportive. They were careful, guarded, the expressions of people who had their own concerns but were not yet ready to voice them, and I made a note to find a quiet moment to talk to each of them separately. Sandra was a landscape architect who had served on the board for 3 years and who, I learned from Gary, had twice tried to propose a formal HOA financial audit and been outvoted by the other board members. She was not Patricia's ally. She was Patricia's hostage, and when I finally got a few minutes alone with her at a neighborhood cookout, she confirmed that with a single exhausted sentence. I've been trying to get out of this board for a year, but she won't accept my resignation. That was the first real crack I found in Patricia's operation. Sandra hadn't wanted to be complicit in any of this, hadn't voted for the bridge inspection scheme, and had in fact written a dissenting memo that Patricia had simply not included in the distributed meeting minutes. A memo Sandra still had a copy of on her personal computer. Phil Rutherford was harder to read. He'd been on the board longer, was quieter, and when I tried to engage him at the cookout he deflected politely, but before he walked away he said something quietly that I held on to. Dan, I'd look into the HOA's maintenance reserve account if I were you. There are questions there that I've been trying to get answered for 2 years. He walked away before I could ask a follow-up. That night I told Marcus what Phil had said about the maintenance reserve, and Marcus went very still in the way he does when something important clicks into place, and he said, Dan, if there's financial irregularity in that reserve account on top of everything else, this isn't just a property dispute. This is potentially fraud, and that changes every calculation in this fight significantly. Marcus and I spent the following weekend going through every piece of HOA financial documentation I'd been able to legally obtain, annual reports, budget summaries, meeting minutes that referenced spending, and the picture that emerged was not clean. Over a 4-year period, approximately $340,000 had been authorized for maintenance and infrastructure projects with no corresponding documentation of completed work, vendor contracts, or permit records. I am not an accountant and Marcus is not a forensic auditor, but neither of us needed to be to see that the numbers didn't add up. Line items for creek bank erosion mitigation, trail connectivity infrastructure, and bridge safety remediation appeared repeatedly in the budget summaries, totaling significant amounts for work that, as best as any of us could tell, had never actually been done. One entry in particular caught our attention. A payment of $62,000 to Crestview Property Solutions for community infrastructure assessment and planning. The same company Dale had said he worked for, the same company registered with Patricia's husband as agent, paid out of the HOA maintenance reserve without any board vote appearing in the distributed minutes. Sandra Chen, when I called her and carefully read her that line item, was silent for a moment and then said quietly, Patricia told the board that vote had already been taken in committee. I never saw the invoice. I signed off on the summary, not the individual payment. I should have asked more questions. There was genuine regret in her voice, not defensiveness. Marcus drafted a formal request for HOA financial records under Virginia's Property Owners Association Act, POAA, which entitled any homeowner to inspect the association's financial records, invoices, and contracts, and we submitted it with a 30-day compliance deadline, sending copies to every board member individually so no one could claim they hadn't received it. Patricia's attorney responded in 22 days, 8 days before the deadline, with a letter stating that the requested records were currently under review by the board's accounting committee and would be made available as soon as that review is complete. A non-answer that Marcus described as a stall tactic, but which reset the clock in a way that bought Patricia more time. We filed a formal complaint with the Virginia Common Interest Community Ombudsman, citing the stalled records request and the procedural violations in the bridge inspection vote. The complaint triggered an automatic notification to the HOA that a regulatory review was pending, which I imagine Patricia received with about as much warmth as a tax audit notice. The effect on Patricia's behavior was subtle but real. The violation notices stopped for 6 weeks, which was the longest gap since we'd moved in, and at the next HOA meeting her tone was slightly more measured, slightly more careful, which told me she'd been advised by her attorney to reduce her litigation exposure while the ombudsman complaint was active. But careful is not the same as restrained, and Patricia did not stay careful for long. About 7 weeks after the ombudsman complaint, I got a call from a neighbor on the north end of the community, a woman named Teresa Walsh, who told me she'd overheard Patricia at a dinner party telling two other board members that she had a plan to resolve the bridge situation before spring, and that it would be done quietly and done right this time. Teresa Walsh was not someone I knew well. We'd exchanged waves and occasional words at the mailbox, but she wasn't in my inner circle of people I'd been coordinating with, which made her tip feel both more credible and more alarming, because it meant Patricia was having conversations about my property in contexts where she didn't expect anyone to be listening. I told Marcus immediately, and he said, "If she's planning something physical, anything involving the bridge itself, you need documentation on that structure right now. Photographs, measurements, a structural assessment from a licensed engineer, everything. You want an ironclad record of the bridge's condition and value before anything happens to it." I hired a licensed structural engineer named Robert Vance from a firm in Alexandria, completely independent, no HOA affiliation, who inspected the bridge thoroughly, tested the planks, assessed the ironwork, and produced a 26-page report concluding that while the bridge showed normal aging for a 32-year-old structure, it was structurally sound, posed no safety risk, and had a replacement value of approximately $47,000 for an equivalent structure. I also hired a historian, actually a colleague of mine from a Northern Virginia Historical Society, a woman named Dr. Elaine Parr, to assess the bridge's historical significance, because I'd remembered something the previous owner had mentioned when we were closing, that the bridge had been built by a local craftsman who was notable for his work in the area during the early 1990s. Dr. Parr's research was the twist I hadn't fully anticipated. The bridge had been built in 1991 by a craftsman named Arthur Keene, who was one of the last traditional cedar bridge builders working in Northern Virginia and who had been recognized by the Fairfax County Historic Preservation Commission in 2003, which meant the bridge potentially qualified for designation as a locally significant historical structure. Dr. Parr filed the paperwork with the Fairfax County Historic Preservation Commission in October, and while the full review process took several months, the filing itself created an immediate notation in the county's property records, a notation that, had anyone pulled the records before acting on that bridge, would have flagged it as under historical preservation review. I did not tell Patricia about any of this. I told Marcus, I told Claire, and I quietly told Gary, but I did not announce it at any HOA meeting or put it in any letter, because I had learned by now that the value of information is its timing, and I wanted this particular piece of information to land at the moment when it would do the most damage to Patricia's plans. The winter passed without the plan Teresa had warned me about materializing. Patricia attended meetings, smiled, distributed HOA newsletters, and acted for all the world as if the ombudsman, complaint, and the county petition dispute were minor administrative inconveniences rather than serious legal threats, which was either supreme confidence or supreme performance, and I wasn't sure which. In January, the Ombudsman's office issued a preliminary finding that the HOA had failed to comply with the financial records request in good faith and ordered the HOA to produce the requested documents within 15 business days, or face administrative penalties. It wasn't a dramatic ruling, but it was the first time a government body had formally found Patricia's HOA in the wrong, and it made the atmosphere at the next board meeting noticeably different. Sandra Chun voted to comply with the Ombudsman's order without any pushback. Phil Rutherford did too, and for the first time, Patricia was outvoted on something 3-2, with the two supporting her being the members who, according to Gary's research, were employed by her husband's landscaping company, which was itself a detail worth noting. The financial records, when they finally came, were incomplete. Invoices for several of the largest Crestview Property Solutions payments were missing, replaced with summary cover sheets that referenced supporting documentation available upon request, which Marcus said was a red flag large enough to see from orbit, and which he immediately flagged in a supplemental ombudsman filing. But something else arrived with the financial records that I hadn't expected. a contract between the HOA and a demolition and excavation company called Terraform Construction, dated 8 months earlier, for removal and disposal of non-compliant private structures in easement-adjacent zones, signed by Patricia as HOA president, with a project description that, through careful reading of the location coordinates in the appendix, referred specifically to my bridge. I stared at that contract for probably 5 minutes before I fully understood what I was reading. Patricia had contracted a company to demolish my bridge 8 months ago, had paid them a deposit with HOA funds, and had apparently been waiting for either the county easement petition to go through or some other legal cover before giving them the go-ahead, which explained why the plan Teresa had heard about hadn't materialized yet. Marcus read the contract and said, very quietly, "Dan, she has already paid someone to destroy your property. If that company shows up, they're not going to check for legal authority. They're going to do what the contract says." He paused. "We need to be ready for this." Ready meant several things. It meant I told Gary to text me immediately if he saw any heavy equipment on our street. It meant the Creekside camera now had a motion-activated alert sent to my phone. It meant Marcus had a draft emergency injunction ready to file within hours of any unauthorized entry. And it meant I started wearing my hiking boots to work instead of dress shoes because I wanted to be able to move fast. It also meant I had a conversation with the 2 neighbors whose properties abutted mine, a couple named the Hendersons on the south side and a widower named Frank DeLuca on the north, and I explained the situation carefully, showed them the contract, and asked if they would be willing to call me immediately if they saw anything unusual near the easement, which they agreed to do without hesitation. Frank DeLuca, as it turned out, had his own Patricia history. She had tried to have his storage shed condemned as visually non-conforming the prior year, a campaign he defeated by producing photographs proving the shed had existed in that location since 1987, a full 4 years before the HOA was even formed. He was quietly one of the most motivated people in the neighborhood. I set the motion alerts to maximum sensitivity. I kept my phone charged to 100% every night. Claire and I talked through the scenario. If the equipment showed up while I was at work, she would call Marcus first, then 911, then me in that order, a protocol we'd rehearsed twice because rehearsing it felt less paranoid than not rehearsing it. The weeks that followed were a strange kind of waiting, normal on the surface, tense underneath, the way a thunderstorm feels in the last hour before it breaks. Everything quiet and green and perfectly still in a way that feels like warning rather than peace, and every morning I walked out to check the bridge the same way I used to check a patient in a hospital, looking for any sign of change. It was in early March that I noticed Patricia doing something new. She started making regular visits to the public greenway on the far side of the creek. Not just walking, but stopping, looking back at my property, taking photographs with her phone, spending 20 to 30 minutes at a stretch surveying angles I couldn't see from my yard, doing it often enough that Frank mentioned it to me unprompted. Whatever Patricia was looking at from across the creek, she had decided something. I could feel it the way you feel a change in weather, something in the quality of the air around the neighborhood shifting, and I texted Marcus to make sure the emergency injunction was still ready and checked that the cameras were all recording and that the footage was being backed up to the cloud automatically. On a Thursday in mid-March, 3 things happened in sequence so fast I barely had time to process one before the next arrived. First, Frank DeLuca texted me at 8:14 a.m. to say a flatbed truck had parked at the end of Creekside Lane. Second, my motion alert fired at 8:22 a.m. with footage of 2 men in hard hats walking toward the bridge from the creekside. And third, Patricia's car pulled into the cul-de-sac at the end of my street at 8:31 a.m. I was at school when the texts came in. I handed my class to the teacher next door, called the principal's office to explain I had a family emergency, and was in my car by 8:36 a.m., calling Marcus from the road while simultaneously watching the camera feed on my phone, where I could now see not 2 men but 4, gathered at my bridge, with what appeared to be a skid-steer loader moving along the creek bank toward them. Marcus was already drafting the emergency filing when I called. He'd been watching the camera feed I'd shared with him weeks ago, and he told me not to approach aggressively, to document everything on my phone, to call 911 and report an ongoing trespass and potential destruction of a historically registered structure, and to get there as fast as I safely could. I called 911 while still driving. The dispatcher was professional and calm. I told her there was an active trespass on my property, that machinery was present, that the property included a structure under historical preservation review, and I gave her my address and the description of the equipment I could see on the camera feed. She told me officers were being dispatched. I pulled onto my street at 8:54 a.m. and saw Patricia standing in the cul-de-sac in her cream blazer, arms crossed, watching the activity at my property with the particular satisfaction of someone witnessing a plan finally executing. And next to her, I could now see clearly, was a man in a suit I didn't recognize who was taking his own photographs of the scene. I parked, got out, and walked toward my property. Not toward Patricia, not toward the suit, toward my own yard. And as I rounded the side of my house, I saw it. The skid steer was already positioned at the base of the bridge, and one of the workers was attaching a chain to the main support post while the other three stood aside watching. And the entire thing was being captured on both my installed cameras and on the phone I was holding with the camera rolling. I said, loudly and clearly, "This is private property and you are trespassing. I am the owner of this property and this bridge. I have not authorized any work here. Stop what you are doing now." I said it twice. I kept the camera on. The workers looked at each other, then at the man in the suit, who said something I couldn't hear from my position and made a small gesture with his hand, and the skid steer operator revved the engine. The skid steer hit the bridge at 8:58 a.m. I have the timestamp on the video. The first impact took out the right support post, and the second, 30 seconds later, buckled the central span. I watched 32 years of cedar and iron fold and collapse into the dry creek bed while I stood there with my phone up and Patricia Weston stood 40 feet behind me, and I did not look away. 2 Fairfax County police cruisers arrived at 9:06 a.m., 8 minutes after the destruction was complete, and the officers were professional and thorough, taking statements from me, from the workers, and eventually from Patricia, who presented them with a copy of the Terraform contract and Patricia's letter authorizing the work, as if a contract between a HOA president and a demolition company was the same thing as a property owner's permission. The officers asked me directly if I had authorized the work. I said no. They asked if I owned the property. I said yes, and I provided the deed documentation I'd brought with me, which Marcus had told me weeks ago to keep in my car precisely for this moment. The look on the lead officer's face when he compared the deed to the contract was exactly what I had hoped for. Patricia, standing 20 feet away, was explaining to another officer that the HOA had authority over easement-adjacent structures, and that the bridge had been a safety hazard. She was using her warmest, most confident, most community advocate voice, and for a moment I thought maybe she was going to talk her way out of it the way she always had. Then the officer who'd been looking at the deed walked over to his partner and showed him something on his phone. I later learned he'd looked up the county's historical preservation notation and found Dr. Parr's filing, which was publicly recorded, and the 2 officers exchanged a look that was brief and entirely communicative, the look of 2 professionals who have just understood the magnitude of what they're standing in the middle of. The lead officer walked back to where Patricia and her attorney were standing and said, calmly, that based on his preliminary assessment, a crime had potentially been committed, that the matter was being referred to the county for further investigation, and that none of the individuals present should leave the jurisdiction without notifying the Fairfax County Police Department. He said it the way officers say things that are extremely serious while maintaining perfect professional composure. Patricia's attorney started speaking, rapidly, in the careful cadence of someone trying to reframe a situation legally in real time, and the officer listened politely and then said, "Sir, I understand your position. You'll have the opportunity to present that in the appropriate venue." He turned away, and that was the moment Patricia's expression changed. Just for a second, just a flicker, but I saw it. I stayed at my property for 4 more hours that day, talking to officers, talking to Marcus on the phone, walking around the wreckage of the bridge and documenting every piece, every broken plank and bent iron railing, every cedar post that had taken 32 years to season into the particular warm color it had been before that morning. And I felt, underneath the cold fury, something I recognized from the worst moments of difficult years: absolute clarity. Marcus arrived at my property at 1:15 p.m. and spent 40 minutes reviewing the camera footage on his laptop, making notes, and then looked up at me with the expression he gets when he's already seen the whole chess game played to its conclusion, and said, "Dan, this is one of the strongest property rights and HOA abuse cases I've seen in 16 years of practice. Patricia Weston has just made every single thing we need to take her down completely available to us on video. The HOA queen bulldozed my wooden bridge, so I made her pay for a brand new one." Marcus filed the emergency civil action that afternoon: trespass, destruction of personal property, conversion, and a claim under Virginia's Property Owners Association Act for abuse of HOA authority. And he requested an emergency temporary restraining order against Patricia Weston personally and against Terraform Construction, prohibiting any further entry onto my property by any HOA-affiliated party. The TRO was granted by a Fairfax County Circuit Court judge the following morning. I have a copy of that order framed in my study now, and it named Patricia Weston, the Maplewood Ridge HOA, and Terraform Construction as respondents, which meant all three were under court order within 24 hours of the bridge coming down. Simultaneously, Marcus filed a criminal complaint referencing the historical preservation notation under Virginia Code Section October 1, 2305, willful destruction of a structure under review for local historical designation. Is a Class 6 felony, and while the threshold for prosecution involves prosecutorial discretion, the filing of that complaint created a paper trail that put the county's Commonwealth Attorney's Office on notice. The Fairfax County Commonwealth Attorney's Office assigned an investigator to the case within the week, a detail I learned when the investigator called me to schedule an interview, which was not something I had expected to happen so quickly, and which told me that whoever reviewed Marcus's complaint had taken it seriously enough to allocate resources immediately. I gave the investigator everything: the camera footage, the contract with Terraform, the historical preservation filing, Dr. Vance's structural report establishing the bridge's condition and replacement value, Sandra Chen's dissenting memo, and the 14 months of documented violation notices I'd been meticulously tracking in my spreadsheet, which I printed out as a 43-page exhibit. The investigator was a quiet woman named Agent Holloway who took exceptionally good notes and asked questions in the precise, layered way of someone who is building a case rather than conducting a conversation. And when I finished presenting everything, she sat back and said, "Mr. Mercer, I want to be clear that I can't comment on what actions may or may not follow from this interview. But I can tell you that we take historical preservation violations extremely seriously in this county." Patricia, I learned from Sandra, had retained a criminal defense attorney by the end of that week, a detail that Sandra conveyed to me in a text message with no commentary attached, but which required no commentary because the hiring of a criminal defense attorney, when you've only been accused of a civil wrong, speaks with perfect clarity about what your own attorneys think your exposure actually is. The civil lawsuit was served on Patricia personally at her home, not on the HOA's attorney, not by mail but personally by a process server on a Tuesday afternoon, and Gary, who had been watching from his porch with the patience of a man who had been waiting for this moment for years, later described the expression on Patricia's face when she received the papers as the first time I have ever seen her look small. The HOA's annual meeting was scheduled for 6 weeks after the bridge incident, and every homeowner in Maplewood Ridge received the notice. But this time, the agenda had been modified by Sandra Chin and Phil Rutherford, who had both submitted items for discussion, including a motion for an independent forensic audit of HOA finances and a motion to consider removal of the current board president under the community's bylaws. I drafted a 2-page summary of everything that had happened: the easement petition, the financial contract with Crestview, the Terraform demolition contract, the criminal complaint, the civil lawsuit, kept it factual, stripped of emotion, documented with references to the public records anyone could verify, and with Gary's help distributed it to every household in Maplewood Ridge 3 days before the annual meeting. The response from the community was not immediate, but it was real. I started getting texts from neighbors I'd barely spoken to, some expressing shock, some expressing the particular vindicated. Exhaustion of people who had experienced Patricia's methods themselves and never believed the neighborhood would collectively reckon with it, and some simply asking what they could do to help. 2 neighbors, independently, told me they had their own documentation of Patricia-related issues they'd never reported because they thought no one would take it seriously. One had a recording of a board meeting at which Patricia had explicitly said a financial decision was already made before any vote occurred, and another had photographs of work done on common areas that matched line items in the HOA budget, but for which no permits had ever been filed. Marcus incorporated that evidence into supplemental filings, and with each new piece, the picture became more complete. Not a HOA president who had made bad decisions, but one who had systematically operated the association as a personal financial vehicle and power structure for nearly a decade, using fines, access restrictions, and selective enforcement as instruments of control. The week before the annual meeting, something happened that I hadn't expected, and that changed the atmosphere of everything that followed. The county building inspector's office, acting on a complaint that Marcus had quietly filed 3 months earlier, cited Terraform Construction for having performed demolition work without the required permits, assessed them a $15,000 fine, and suspended their operating license pending a safety review, news that traveled through the neighborhood faster than anything the HOA newsletter had ever distributed. In the days before the annual meeting, the neighborhood reached a kind of suspended stillness. Patricia continued her routine, was seen walking her dog, waving to neighbors from her driveway, maintaining the surface of everything that had always made her so effective, but something had shifted in the quality of those interactions, something invisible but unmistakable, the way a crowd shifts when someone realizes the person at the front of the room doesn't actually have the authority they've been acting like they have. Claire asked me one evening, after the kids were in bed, whether I thought we'd done the right thing in pursuing all of this so aggressively. Not second-guessing, just processing, and I told her honestly that I wasn't interested in destroying Patricia as a person, that I would have been happy to live peacefully in this neighborhood if she'd left my property alone, but that what happened to our bridge had not been an accident or an error. It had been a choice made deliberately with planning and forethought, and it deserved to be treated as what it was. Claire said, "I know. I just want to make sure we're doing this for the right reasons." I told her we were doing it because the bridge was gone, the money to replace it was significant, our legal rights had been violated, and Patricia's operation had hurt other people in this neighborhood who hadn't had the resources or knowledge to fight back, and those reasons were enough. Marcus called me the night before the annual meeting to tell me that Terraform Construction had reached out to his office to discuss a potential settlement. They were clearly trying to separate themselves from Patricia's liability and were prepared to discuss damages, which was their first acknowledgement that they understood they had done something wrong and that the video evidence made denial pointless. I told Marcus to hear them out, but to make clear that any settlement with Terraform would not affect the civil action against Patricia personally or the HOA. I wasn't interested in letting the demolition company serve as a shield that protected the person who had given them the order, which was how Patricia would have preferred things to work out. Sandra Chen called me the afternoon before the meeting and said she was going to move forward with the motion to remove Patricia from the board presidency, and that she had the votes she needed. She sounded nervous but determined, and she asked me directly whether I would be present at the meeting to speak during public comment, which I said yes to. Phil Rutherford sent me a text that same afternoon. "Bring your documentation. All of it. Printed. This needs to be on the record." I appreciated his economy of language. Phil was a man who said exactly what he meant and nothing more. which was a quality I'd come to value over months of dealing with Patricia's carefully constructed ambiguity. Gary showed up at my door that evening with a six-pack of beer and said, "Tomorrow's going to be a day, brother." We sat on the porch for an hour watching the creek trail and talking about nothing in particular. His kids, my lesson plans, the spring weather, ordinary life, and I was grateful for it because for the past 14 months ordinary life had felt like a background I couldn't fully access. I slept better that night than I had in months. Not because I was certain about how the meeting would go. I wasn't. But because the uncertainty had a shape now, and I had done everything within my power to prepare for it, and whatever happened next would happen in the open, on the record, with documentation that couldn't be revised or redacted after the fact. Claire made coffee at 6 a.m. and we sat at the kitchen table before the kids woke up, and she said, "Whatever happens at that meeting, I'm proud of how you handled this. You didn't lose yourself." It was exactly the right thing to say, and I held it the whole day. The morning of the meeting, I received an email from Dr. Parr, the historical preservation historian, informing me that the Fairfax County Historic Preservation Commission had completed its expedited review, accelerated in part due to the documented destruction of the structure, and had officially designated Arthur Keene's Cedar Bridge at 1847, Creekside Lane as a locally significant historical structure, retroactively, which Dr. Parr said was unusual but not unprecedented, and which meant Patricia had destroyed a property that was now formally recognized as historically significant. I forwarded that email to Marcus in under 60 seconds. He called me back in under 2 minutes. "Dan," he said, "do you know what retroactive historical designation does to the criminal charge here?" I told him I had a guess. He said, "It elevates the severity of the sentencing guidance. I'm filing this with the Commonwealth Attorney's Office today." The irony, and I did not enjoy it, I simply noted it, was that if Patricia had left the bridge alone, it would have continued to age as a private structure on private property, modestly noted in historical society files, legally untouchable but also not in the spotlight. By destroying it, she had triggered a chain of events that made it officially significant, officially documented, and officially the evidence at the center of a criminal investigation. I drove to the HOA annual meeting that evening with a folder of documents, a laptop with the camera footage, and the knowledge of Dr. Parr's designation letter, which no one in that room except Marcus and Claire knew about yet, and I sat in the third row next to Gary and waited for the meeting to begin with the patience of someone who had learned, over a very long year, that timing is everything. Patricia walked in 3 minutes after the meeting was called to order. She never arrived late, which was itself a message, and she was wearing the cream blazer because of course she was, and she smiled at several neighbors and took her seat at the president's table with the composure of someone who had not yet read Dr. Parr's email, had not yet spoken to her attorney that afternoon, and did not yet know that the ground beneath her had shifted permanently. The meeting opened with routine matters, treasurer's report, committee updates, and Patricia handled them with brisk efficiency, her default mode, the performance of a competent executive, and I watched her and thought, she still thinks she can manage this the way she's managed everything else, through force of personality and procedural control, and she doesn't know yet that neither of those tools works in the situation she's actually in. Sandra Chen moved to table the routine agenda after the first 2 items and called for a special discussion session under the board's bylaws provision for member-initiated agenda items. Patricia started to object and Sandra said, calmly and clearly, "Sandra Chen, board member, invoking Section 8.4 of the Maplewood Ridge HOA bylaws. Motion is in order." "Phil, do I have a second?" Phil said second before Patricia could speak again. The room shifted in a way that was physical. Chairs moving, people sitting up straighter, the particular attentiveness of a crowd that senses something real is about to happen rather than the usual performance of a community meeting, and I could see Patricia recalibrating in real time, her expression smoothing out into the composed, slightly wounded face she deployed when she felt threatened. Sandra presented a motion for an independent forensic audit of HOA finances covering the past 5 years, citing specific line items from the financial records, including the Crestview payments and the Terraform contract, and she did it carefully, factually, without drama, reading directly from printed documents, and when she finished the room was very quiet. Patricia said, "I want to address some of the concerns Sandra has raised, because I think there's been some significant misunderstanding about the context of those expenditures." She began to explain, and she was good, I'll give her that, fluid and confident and just sympathetic enough to make you want to believe her. But 2 things had changed since the last time that approach had worked for her. The first thing that had changed was that 40% of the people in that room had read my summary document, and the ones who hadn't had talked to neighbors who had, which meant most of the audience was evaluating her explanation against a framework of documented facts rather than accepting it at face value. You could see it in the quality of their listening, the slight skeptical tilt. The second thing that had changed was me. I raised my hand during the public comment portion and said, "My name is Daniel Mercer. I own the property at 1847 Creekside Lane. I'd like to introduce some documents into the public record of this meeting." I laid the folder on the table, 43 pages of violation notices, the Terraform contract, the ombudsman finding, the Crestview payment records, the engineer's assessment, and I handed copies to both board secretaries. Then I opened my laptop and said, "I'd also like to show, with the board's permission, approximately 4 minutes of camera footage documenting the unauthorized demolition of my property on March 14th. Sandra nodded. Phil nodded. The third board member who wasn't aligned with Patricia looked at Patricia and then looked away and said nothing. I hit play. The room watched in silence. 4 minutes and 11 seconds. The skid steer, the workers, the chain on the support post, the first impact, the collapse, Patricia standing in the cul-de-sac in the cream blazer with her arms crossed. The ambient sound of machinery and breaking wood. I had not rehearsed a narration. I let the footage speak because it was better at it than I was. When it ended, there was a moment of complete stillness, and then several things happened at once. 2 people started speaking, 3 people pulled out their phones, and Patricia's attorney, who had apparently been sitting in the back of the room, which I had not noticed until that moment, stood up and said, "I'd like to object to the introduction of this material." And Sandra said, flatly, "This is a homeowners association annual meeting, not a court. Your objection is noted and declined." Patricia spoke then. She had to, the silence was costing her more than speaking would, and she said that the bridge had posed a documented safety risk, that the HOA had followed proper procedures, that there had been some miscommunication about the property boundaries, and she used the phrase "in good faith" twice in 30 seconds, which, in my experience, is always the signal that faith has not been operating in good faith. A woman named Carol Huang, who had lived in Maplewood Ridge for 14 years, raised her hand and said, "Patricia, I've received 11 violation notices in 4 years. I went back and checked the ones from the first 2 years against the CC and RS tonight after reading Daniel's summary, and 6 of them cite rules that aren't in the CC and RS. Where do those rules come from?" The room shifted again. Patricia started to answer and another hand went up. A man named Robert Telfer, who I knew only slightly, and he said, "I paid a $500 fine 4 years ago for a fence that the HOA said was the wrong color. I have that notice here. The rule it cites is the same supplemental addendum that doesn't appear in the original CC and RS. I'd like to know who approved that addendum and when." 2 more hands went up. This was the thing Patricia had not accounted for. She had operated by isolating her targets, dealing with each household separately, keeping grievances atomized so that no one had the full picture, but my summary document had functioned as a Rosetta Stone, giving people the framework to decode their own experiences, and now the isolation was gone. For 45 minutes, homeowner after homeowner spoke, calmly, specifically, with dates and amounts and citations, and the cumulative weight of it was something different from any single complaint or lawsuit, It was the documented record of a 9-year pattern, laid out in the voices of the people who had lived through it, in a room where everyone could hear everyone else for the first time. Patricia tried twice more to regain control of the narrative. Once with a procedural objection that Sandra overruled, once with a prepared statement that she read from her phone, speaking quickly in the practiced cadence of managed crisis. But the room wasn't receiving it, not the way it once had, and she could feel it. Sandra called the vote on the forensic audit motion. 3 in favor, 2 against. The forensic audit was approved. Next, Sandra introduced a motion under Section 14.2 of the bylaws to remove a board officer for cause, citing documented evidence of financial mismanagement, unauthorized use of HOA funds, and abuse of enforcement authority. She read the motion clearly, calmly, and with the particular dignity of someone who has been waiting a long time to say something that needed to be said. Patricia's attorney objected again, this time citing procedural requirements for removal, arguing that 30 days' notice was required before a removal vote could be taken. And Sandra slid a document across the table and said, 31 days ago I hand-delivered a certified letter to Patricia's home residence citing Section 14.2 and notifying her of a potential removal motion at the annual meeting. She signed the return receipt. The document is in your hand. The attorney looked at it and said nothing. The vote on Patricia's removal from the board presidency. 3 in favor, 2 against. Patricia Weston was removed as president of the Maplewood Ridge HOA by a board vote in a room full of the community she had controlled for 9 years, at 9:14 p.m. on a Wednesday in April, and the sound in the room when the vote was announced was not cheering. It was exhale, the long exhale of a place releasing pressure it had been holding for longer than anyone had fully realized. Patricia stood up from the president's table. She looked around the room with an expression I will try to describe accurately. Not broken, not remorseful, not even fully surprised, but recalculating. The expression of someone whose plan has failed and who is already computing the next move, which told me we were not done, that removal from the board presidency was not the end of this, that she still had the lawyers and the financial resources and the particular will of someone who does not accept defeat. She walked out of the meeting room with her attorney without speaking to anyone, and the door closed behind her, and Sandra Chen moved immediately to the next item on the agenda, establishing an interim board governance structure while the forensic audit was conducted, because there was real work to do and Sandra was, above everything else, a practical person who understood that justice doesn't run the community while you celebrate it. I drove home that night with Gary in the passenger seat and we didn't say much. There was a particular kind of tired that comes after a long fight reaches a turning point, not victory fatigue but something more like relief fatigue, the body realizing it can finally stop bracing. And when I pulled into my driveway and looked toward the back of the property where the bridge used to be, I felt the loss of it freshly, which surprised me. Claire was awake when I got home. She'd put the kids to bed and was sitting at the kitchen table with tea and a book she hadn't been reading. And she looked at my face and said, "How did it go?" And I sat down and told her everything in order. And she listened and nodded, and at the end she said, "Good, now we finish it properly." That was Claire. The forensic audit firm, hired by the reconstituted board within 2 weeks of the meeting, was an independent CPA firm from Richmond with HOA audit experience. Sandra had vetted them personally, and they began the review with access to 9 years of financial records, bank statements, vendor contracts, and HOA communications that the prior board's financial records chair had been quietly copying and preserving in a separate archive for the past 2 years. The detail about the archive was the second twist I hadn't seen coming. It turned out that the HOA's financial records chair, a quiet retired accountant named Meredith Cole, had been documenting irregularities for 2 years and making personal copies of all financial records, not knowing exactly what to do with them but having the instinct that they would be needed someday. She handed the audit firm 11 binders of meticulously organized documentation. Meredith had been on my radar as a peripheral figure. I'd spoken to her twice briefly, But I had not known about the archive until Sandra told me the week after the meeting, and when Sandra described Meredith sitting at the audit firm's conference table with 11 binders lined up in front of her. I felt a profound respect for the quiet, patient courage it takes to document wrongdoing when you're the only person in the room who sees it. The Terraform construction settlement offer arrived through Marcus's office 3 weeks after the annual meeting. $52,000 for destruction of the bridge, plus a $5,000 payment for trespass damages, plus a written acknowledgement that they had entered my property without authorization and that the decision to do so had been made by Patricia Weston. That last clause, the written acknowledgement, was the piece Marcus had made non-negotiable. I accepted the Terraform settlement. $57,000 deposited into my account within 30 days of execution, along with their signed acknowledgement, which became an exhibit in the ongoing civil case against Patricia personally, and which, because it was a signed legal document from a co-defendant establishing the facts of the incident, significantly strengthened our position. Patricia's personal attorneys filed a motion to dismiss the civil case citing qualified immunity under her role as HOA president. A creative argument, Marcus said, but not a winning one, because HOA presidents in Virginia do not have governmental immunity, and what Patricia had authorized was not a board decision but a unilateral action using HOA funds without a properly noticed vote, which made it personal liability rather than organizational action. The motion to dismiss was denied in June. The civil case was set for trial in October. Marcus sent me the scheduling order with a note that said simply, "We're going to trial. Everything we've built will matter." I printed it and pinned it above my desk at school. The forensic audit results came in late July. A 112-page report that I will not summarize in full, but the relevant findings included $87,000 in HOA funds paid to Crestview Property Solutions for services that could not be verified as performed, $23,000 in funds transferred to an account linked to Patricia's husband's landscaping company without board authorization, and approximately $44,000 in fines collected from homeowners under rules that had never been formally adopted through the required bylaw amendment process and were therefore legally unenforceable, which meant the HOA owed those fines back to the homeowners who had paid them. That last finding, the refund obligation, was the one that landed hardest in the neighborhood, because it affected nearly everyone who had ever paid a violation fine, which included almost every household that had been targeted over 9 years, which meant the HOA had been operating an illegal fine collection system on a community-wide scale for close to a decade. Marcus filed the audit report as a supplemental exhibit in the civil case and forwarded it to the Commonwealth Attorney's Office as additional evidence in the criminal investigation, and he also sent it to the Virginia Department of Housing and Community Development, which has oversight authority over community associations in the state, triggering a separate regulatory investigation. By August, Patricia Weston was facing a civil trial in October, a criminal investigation by the Commonwealth Attorney, and a regulatory investigation by the state, and the community she had controlled for 9 years had voted to remove her, commissioned an audit that documented her misconduct, and was in the process of refunding fines she had illegally collected, with her name attached to each explanation letter the new board sent out. I want to be clear that during this period I was still teaching high school history, grading papers, running lessons on the civil rights movement and the constitutional limits of authority, having exactly the conversations about power and accountability that felt uncomfortably personal. And my students occasionally asked me if I was okay because I sometimes got a faraway look during class, which I attributed to planning, which was technically accurate. The one place I found genuine peace in those months was the creek behind my property. I'd taken to walking down to the bank in the evenings, standing where the bridge had been, watching the water when the rains came and the creek ran, and thinking about Arthur Keene, the craftsman who'd built it in 1991, who I'd learned from Dr. Parr had built 4 other bridges in Northern Virginia, all of them still standing. I reached out to Arthur Keene's family. He had died in 2009, but his son, a carpenter named William Keene, lived in Herndon, Virginia, and I explained what had happened to the bridge, what the historical designation meant, and that I wanted to discuss rebuilding it in a way that honored his father's craft and the structure's documented history. William Keene drove out on a Saturday and stood at the creek bank for a long time without speaking. He said finally, "My dad was proud of this one. He talked about it." He looked at the broken cedar posts still lying in the creek bed, the bent iron railings, and I watched his face process the destruction the way you watch someone absorb a loss they've been told about but not yet seen. And when he looked at me, his expression had the particular quality of resolved purpose. "I'll build you a new one," he said, "better than the old one." That conversation was the one moment in all of this where the grief of losing the bridge felt clean rather than angry, because William Keene was standing there. And the craft wasn't gone, just interrupted, and some things can be restored even when they cannot be recovered, which is a distinction worth understanding. Marcus called me in early September with news from the Commonwealth Attorney's Office. They had filed formal charges against Patricia Weston under Virginia Code Section October 1, 2305 for willful destruction of a locally designated historical structure, a Class 6 felony, as well as 2 counts of common law conspiracy in connection with the unauthorized use of HOA funds. Patricia was arraigned on September 8 and entered a not guilty plea. The criminal charges became public record immediately, and the story moved beyond the neighborhood. A local TV station in Northern Virginia ran a brief segment on HOA president faces felony charge after demolition of historical bridge. And while I declined to be interviewed, the footage came from the county court's public records and from Dr. Parr, who gave a thoughtful statement about the significance of the historical designation and the importance of preservation. The TV segment triggered a wave of attention I hadn't anticipated. Emails from other homeowners in the region describing similar HOA abuses, messages from property rights advocacy groups offering support, and one email from a journalist at a regional publication who had been working on a longer piece about HOA governance abuse in Northern Virginia and wanted to include our case as a documented example. I talked to Marcus before deciding anything about public communications, and he advised me to let the legal proceedings speak without embellishment. The facts were already extraordinary, and anything I said that could be characterized as self-promotion or revenge narrative would give Patricia's defense attorney's material to use against us. So I declined the journalist's interview with a brief, polite note and pointed him to the public court records. What I didn't decline was a request from Sandra Chun and the new HOA board to speak at a community town hall in late September. Not about the legal proceedings, but about HOA governance reform, what homeowners could do to protect themselves, what warning signs to watch for, and what the community was now doing differently to ensure that what had happened under Patricia's tenure could not happen again. I spoke for 20 minutes and answered questions for another 40, about the CC&RS, about homeowner rights under Virginia's POAA, about the difference between legitimate HOA authority and the kind of unilateral action Patricia had taken, and when I finished, Meredith Cole, the quiet accountant with the 11 binders, raised her hand and said, "I want everyone to know that I should have spoken up sooner. I hope someone else in some other neighborhood is listening to this tonight." There was a silence and then genuine applause, and I thought it might be the most important thing said all evening. The civil trial was scheduled for the 3rd week of October. Marcus had been preparing for months: depositions, interrogatories, document requests, motions in limine, and by the time we were a week out, the case file was 3 inches thick and the evidence was, in his words, as airtight as a case gets when the central event is on video and the defendant's own attorney helped plan it. Patricia's defense strategy, as best as we could understand from the pretrial filings, was threefold. First, that the HOA had legitimate safety authority over easement-adjacent structures. Second, that Patricia had acted in good faith on advice of counsel. And third, that the historical designation was retroactive and therefore couldn't elevate the severity of the destruction, legally speaking, arguments that Marcus described as not insane but not winners. The good faith reliance on counsel argument was the one Marcus spent the most time preparing against, because it required him to demonstrate that Patricia had not, in fact, received legal advice authorizing her to destroy my bridge, which meant deposing her attorney, which had produced some genuinely remarkable deposition testimony about the specific advice given and not given, testimony that Marcus said he was looking forward to using. Patricia's attorney had apparently told her, in writing, that the HOA had potential authority over easement-adjacent structures, but that any action required confirmation of proper legal basis and owner notification. Language that stopped well short of authorizing demolition without consent, and which Patricia had apparently received and then proceeded to authorize the demolition anyway, which was documented in the email chain Marcus had obtained in discovery. The pretrial hearing on September 30th was the first time I saw Patricia in a formal legal setting. She was well-dressed, composed, seated beside her attorneys with the posture of someone who has decided. That dignity is the only card she has left to play, and I watched her and felt, to my surprise, no satisfaction and no contempt, only the particular clarity of seeing someone fully for the first time. The judge denied Patricia's motion to exclude the camera footage. She tried to argue it had been obtained in a way that violated privacy expectations, which was factually wrong since the cameras were on private property recording activity on that same property, and the exclusion of that motion meant the trial would proceed with the video evidence, which was the foundation of everything. On the Friday before trial, something happened that I had not seen coming and that Marcus called the most significant development in the entire case. Patricia's co-defendant, Terraform Construction, who had already settled with me, filed a declaration with the court, in which the company's owner provided a sworn statement that Patricia had personally directed the demolition with full knowledge of the property boundaries, and that when the Terraform supervisor had raised a concern about potential trespass, Patricia had told him in these exact words that the HOA has authority here and you have a signed contract, so do your job. That declaration was devastating. It removed every ambiguity about intent, about knowledge, about whether Patricia had believed she had authority. She had been told by her own contractor that there was a trespass concern, and she had overridden it, which meant this was not a mistake, not a misunderstanding, not a good faith error, but a deliberate act executed with full knowledge that it might be unauthorized. Marcus called me after he received the declaration and said, "Dan, I think you're going to see a settlement offer before Monday." I asked what kind of number. He said, "With this declaration in the file? Whatever number you want." I told Marcus the number I wanted was not a number. It was a written public acknowledgement, a full restoration of the bridge at Patricia's personal expense, not HOA funds, a formal community apology distributed to every homeowner in Maplewood Ridge, and a resignation from any future involvement in HOA governance in the state of Virginia. The money was secondary. Marcus was quiet for a moment and then said, "I'll communicate that." Patricia's attorneys called Marcus's office on Sunday. They wanted a call on Sunday that told me everything I needed to know about where things stood. The settlement call lasted 2 hours and 40 minutes. I wasn't on it. Marcus handled it, relaying developments to me by text, and I followed along from my living room while Claire graded papers at the kitchen table and the kids watched a movie in the other room, the ordinary Sunday life of our household running its course while, in a conference room somewhere, the terms of Patricia's accountability were being negotiated. Patricia accepted every condition except the community-wide apology letter. Her attorneys argued it would constitute an admission in the pending criminal case, and Marcus, after consulting with me, agreed to modify that term to a statement of responsibility that her attorneys had reviewed, which accomplished the same purpose through slightly different language. The settlement was executed on Monday morning, 6 days before trial, signed by Patricia Weston personally, not through the HOA and not through Terraform, but by Patricia herself in ink on a document that would be filed with the court as a public record and that included a provision requiring her to fund the reconstruction of the bridge through a payment of $72,000 directly to William Keene's construction company within 30 days. $72,000. More than the terraform settlement, more than the engineer's replacement estimate, because Marcus had argued for and received a premium representing the historical significance of the original structure. A premium that the terraform declaration made impossible to contest, because if Patricia had deliberately destroyed a historically significant structure, the restoration value was higher than simple replacement cost, and her attorneys knew it. The 30 days following the settlement were quieter than anything I'd experienced in the preceding 16 months. Not peaceful exactly, but deflated, the particular quiet of aftermath, as if the neighborhood had used up all its available tension and needed time to rebuild a baseline before anything could feel normal again. Marcus filed the settlement agreement with the court, which closed the civil case. And with it went the energy that had powered everything, the constant readiness, the phone always charged, the cameras always checked, the litigation rhythm that had structured my evenings for over a year. And in its absence I found myself a little lost. The way you're a little lost after a long project ends and you haven't yet figured out what you're supposed to be doing with the time. Patricia's criminal case continued. The settlement of the civil matter had no bearing on the Commonwealth Attorney's prosecution, and her arraignment had already been entered, so the criminal process would proceed to its own resolution regardless of what we had agreed privately. Marcus kept me informed but made clear that I was now a witness rather than a party. A shift in role that felt strange after so long of being at the center of everything. William Keene came to the property in mid-October to survey the creek bank and plan the reconstruction. He brought his own measurements, his father's original blueprints, which he'd found in a box in his mother's attic after our first conversation, and a young carpenter he was training, a quiet kid named Marcus who happened to share a name with my attorney, which I took as a mild cosmic sign. William walked the creek bank for almost an hour, measuring angles, testing soil stability, assessing the footings from the old bridge that were still partially embedded in the bank. And he showed me the original blueprints and pointed out details in his father's design that I'd never noticed in 6 years of crossing that bridge. The way the cedar planks were cut at a slight angle to shed water more effectively, the custom-forged iron brackets that Arthur Keene had sourced from a blacksmith in Manassas, the specific species of cedar selected for its resistance to moisture. He built things to last, William said, studying the blueprints. This was supposed to be here for 100 years. I thought about what Patricia had done to those 100 years and felt the anger rise and then settle, the way it had learned to do over the past months. Not gone, just managed, contained in a compartment where it could be useful rather than consuming. The reconstruction would take approximately 6 weeks. Longer than a standard bridge project because William was committed to replicating the original design faithfully, sourcing materials that matched Arthur Keene's original specifications as closely as possible, including the cedar species and the iron work, which he was having reproduced by a metalworker in Culpeper who specialized in historical reproduction. The $72,000 arrived from Patricia's account on November 3rd. Marcus confirmed receipt and transferred the construction funds to William Keene's company directly, with the remainder going into an account for property costs and legal fee reimbursement. And I stood in my kitchen looking at the bank notification on my phone and thought about the morning in March when I had watched the skid steer take the first swing. Patricia resigned from every civic and community organization she was affiliated with in Maplewood Ridge in the weeks following the settlement: the Garden Club, the Neighborhood Watch Committee, the County Parks Advisory Board on which she'd served for 4 years, and whether that was strategic, to reduce public exposure during the criminal proceedings, or genuine, an acknowledgement that her position in the community was untenable, I couldn't say, but either way the effect was the same. The community around her adjusted. The neighborhood had not existed without Patricia as a dominant presence in nearly a decade, and the recalibration was visible in small ways. Meeting attendance changed. The tone of community communications became less formal and more direct. People who had been quiet at meetings started speaking. The culture of the place began, slowly and tentatively, to become something different from what it had been. I taught a unit on the civil rights movement that November that happened to include a discussion of community organizing, the mechanics of collective action, and the difference between institutional power and legitimate authority. And I found myself drawing from recent experience in ways I didn't entirely plan, not sharing the specifics, just drawing from the truth of what I'd observed about how power works and what it takes to shift it when it has calcified. Lily, my older kid, asked me one evening at dinner why the bridge was being rebuilt, and I explained, in age-appropriate terms, that the bridge had been destroyed unfairly and that we'd worked hard to make sure the person responsible had to fix what they'd broken, and that sometimes when someone does something wrong there are consequences, and those consequences had happened here. Lily said, "Is the lady in trouble?" And I said yes. She thought about it and then said, "Good." Ben, who was 8 and had been listening silently, said, "Was she mean?" And I said, "She made choices that hurt people, yeah." He nodded slowly and went back to his dinner, and Claire caught my eye across the table with an expression that was equal parts warmth and exhaustion. The criminal case moved to a preliminary hearing in December. I attended as a witness, gave testimony about the morning of March 14th, was cross-examined by Patricia's defense attorney for 40 minutes, and answered every question truthfully and completely, which in practice meant that the cross-examination confirmed rather than undermined the prosecution's evidence, because the truth has that quality when it's consistent. The preliminary hearing judge found sufficient probable cause to proceed to trial on the felony charge. The second count of common law conspiracy was reduced to a misdemeanor at this stage, and Patricia was bound over to the circuit court for trial, which was scheduled for the following spring, and she walked out of that hearing with her attorneys in close formation, not speaking, not looking at anyone. I was in the parking lot of the courthouse when she came out, not by design. I'd been talking to the prosecutor's investigator, Agent Holloway, and Patricia and I were briefly in each other's line of sight across maybe 30 feet of parking lot, and she looked at me for a second and then looked away, and I looked back at the courthouse entrance, and that was the entirety of the last direct contact I have had with her. Marcus filed the final paperwork closing out the civil case in December, and I took him and his family to dinner, his wife, his 2 teenage daughters, at a restaurant in Arlington that he liked, and we ate and talked about things entirely unrelated to HOA law for 3 hours, which was one of the best evenings I'd had in a long time. The Fairfax County Historic Preservation Commission held a small ceremony in December to formally document the Keene Bridge. They gave it that name, Keene Bridge, after the craftsman who built it, and Dr. Parr spoke about its significance and about the unexpected way its destruction had accelerated its formal recognition, which she described with the careful optimism of a historian who has learned to find meaning in strange places. I attended the ceremony alone. Claire was at a school event with the kids, and I stood in the backyard in December air and listened to Dr. Parr speak and watched William Keene, who had also attended, stand with his hands in his coat pockets looking at the creek bank where the construction had already begun, the new footings already poured, the cedar beams beginning to take shape. At the reception afterward, a woman I didn't recognize approached me and introduced herself as Helen Weston, Patricia's sister-in-law. She explained quickly, Patricia's husband's younger sister, someone who had no role in any of the HOA operations, and she said she wanted to apologize personally for what had happened to my property, that she was horrified, that the family was fractured over it, that Patricia had not been well for some time in ways that didn't excuse anything but perhaps explained some of it. I thanked her. I told her the apology wasn't hers to give, which she acknowledged, and I told her I bore no ill will toward anyone who hadn't been part of what happened, which was true. We spoke for about 5 minutes and parted, and I walked home through the December evening thinking about the complexity of people and families and the way that even the most straightforward injustice exists inside a human context that doesn't simplify it. January was quiet. William's crew worked 3 days a week on the bridge in the cold. They were careful with the cedar in winter temperatures, keeping it under protective covering between work sessions, and I checked the progress from the kitchen window in the mornings before school and watched the structure taking shape, plank by plank, the new bridge rising from the same bank as the old one. The new board's governance reforms were approved by a homeowner vote in January. A formal amendment to the CC and RS establishing a mandatory external audit every 2 years, requiring any supplemental rules to go through a formal bylaw amendment. Process with proper notice and voting, establishing a homeowner ombudsman role within the association, and reducing the HOA president's unilateral authority in ways that made a repeat of Patricia's operation structurally impossible. Gary texted me the morning after the governance vote. 9 years, brother. 9 years of that. And we changed it in one vote. I texted back a single thumbs up because I was at school and couldn't write a full response, but I thought about it all day, how long things can go wrong before they go right, and how much it costs the people in the middle, and how worth it the fight is when you get to the other side. The refund checks for illegally collected HOA fines went out in February. The new board had set aside a portion of the forensic audit recovery to fund them, and I received one myself, for the light bulb fine and 2 others that had been cited under the unenforceable addendum, totaling $480, which I donated to a legal aid organization in Fairfax County that helped low-income homeowners fight HOA abuses. It seemed like the right use of the money. It seemed like exactly the right use of the money. The criminal trial was set for April, and as it approached, I became aware of something I hadn't expected to feel. I didn't want to attend. Not because I doubted the case, not because I wanted Patricia to escape accountability, but because I had spent 16 months in a combat posture and I was genuinely, deeply tired of the whole of it, and I needed to let the legal system do its part while I returned to actually living in my house and my neighborhood. Marcus said that was completely understandable and that my presence in the courtroom was not required. I had given my testimony at the preliminary hearing, it was in the record, and the case would proceed with or without my attendance, and he promised to keep me informed of each development, which he did by text in the efficient, annotated way of a person who understands that I needed information but not a running narrative. The weather in March was warm enough to work outside, and William's crew accelerated. I came home from school one afternoon to find the bridge half complete, the new cedar planks laid across the central span, the ironwork brackets, installed and gleaming with the particular quality of new metal that hasn't yet been worn into familiarity, and I stood at the edge of the creek bank and felt something crack open in my chest that I hadn't let myself feel for a long time. Ben came running out from the house when he saw me standing there and stood next to me looking at the bridge and said, "It's so pretty, Dad." And I said, "Yeah, buddy, it is." And I meant it in a way that was bigger than the bridge and smaller than everything that had happened to get to that afternoon, which is about the right scale for moments like that. The iron railings went up in late March. William had spec'd them to match Arthur Keane's original design but with slightly heavier gauge metal, more durable in wet conditions, and when they were installed the bridge looked, I thought, more substantial than the original, more grounded, as if the reconstruction had learned something from the destruction and built it into the structure itself. I walked across the new bridge for the first time on a Saturday morning in early April. Just walked across it and back slowly, testing the planks with each step the way you test something you're not sure you can trust yet, and it held, solid and even, with the particular resonance of cedar underfoot, and I stood on the far bank looking back at my house and thought, this is what it was supposed to be all along, what it always should have been. The bridge was officially complete on April 11th. William Keane stood in my backyard with his apprentice and accepted the handshake I offered him with the particular quiet dignity of a craftsman who has done work he's proud of and doesn't need more ceremony than that. And he said, "My dad would have been glad." And I believed him. Dr. Parr came to see the completed bridge and photographed it extensively for the Historical Society records. The new Keene Bridge, as it would be known officially, documented in the County Historical Register. As a reconstruction of the original 1991 structure by the original builder's son, in the original materials and design, which she said was the kind of continuity that historians rarely got to observe in real time. Marcus called me that evening to tell me the criminal trial had begun that morning, and that Patricia had changed her plea to no contest on the felony charge. Alfred plea, he explained, which meant she wasn't admitting guilt but acknowledged the prosecution's evidence was sufficient for conviction, which meant there would be no trial, just sentencing, which was scheduled for May. I sat with that information for a while. No trial. The thing I'd been bracing for since September was not going to happen the way I'd expected, and in its place there would be a sentencing hearing and then whatever came after, and the whole apparatus of legal conflict that had structured my life would resolve not in a dramatic courtroom confrontation but in a quiet procedural pivot, which was perhaps the most appropriate ending. Not dramatic, just inevitable. The HOA queen bulldozed my wooden bridge, so I made her pay for a brand new one. The sentencing hearing was held on May 14th in Fairfax County Circuit Court, and I did attend, not for satisfaction, not for the theater of it, but because I had given testimony in that case and I felt a responsibility to see it to its conclusion in person, to be present in the room where the legal system finished what it had started, and because Marcus would be there and I wanted to be with him for it. The courthouse was the same building where I had attended the preliminary hearing in December. A beige stone building off Chain Bridge Road with the quiet seriousness of a place that has processed a very large number of human mistakes and their consequences, and I arrived 20 minutes early and sat in the gallery and watched people file in with the varied expressions of people who come to these things for very different reasons. Patricia arrived with her 2 attorneys, not the HOA's attorney who had stepped back after the civil settlement, but 2 criminal defense attorneys in good suits who positioned themselves around her in the particular way of people managing an asset. And she was dressed quietly, conservatively, a gray blazer today instead of cream, and she sat at the defense table with a composure that I recognized as performance but that I also recognized as very good performance because it had always been. The gallery was not full. This was a felony sentencing for a HOA president in Northern Virginia, not a national story, but there were perhaps 20 people present, including Sandra Chen, Phil Rutherford, and Gary, who was sitting 2 rows behind me and who caught my eye and gave a single, brief nod that communicated more than any speech could have. Meredith Cole was also there, the accountant with the 11 binders, sitting near the back in a brown coat, hands folded, watching the proceedings with the careful attention of someone who had spent 2 years preparing evidence for exactly this kind of room and wanted to see where it landed. The prosecutor, an assistant Commonwealth attorney named James Redding who had handled the case from the beginning, presented the sentencing recommendation: 2 years of supervised probation, a $25,000 fine, 200 hours of community service, and a permanent prohibition from serving in any fiduciary capacity in a property owners association or similar community organization in the Commonwealth of Virginia. Redding was thorough and measured in presenting the case for that recommendation. He referenced the camera footage, the historical designation, the financial audit findings, the Terraform Declaration, the 16 months of documented HOA violations, and he described Patricia's conduct not as a moment of poor judgment but as a sustained pattern of abuse of authority that had harmed multiple members of the community over a period of years. He said, "Your Honor, what the defendant did on March 14th was not a lapse. It was the culmination of a 9-year practice of treating community governance as a personal instrument. The bridge she destroyed was not just a structure. It was a documented piece of local history, belonging to a family that had done nothing except assert their legal rights." I wrote those sentences down. Patricia's attorneys presented mitigating factors: her 9 years of volunteer community service, her contributions to neighborhood improvement, character letters from friends and acquaintances who described her as dedicated and caring, letters that I read carefully and that described a person I recognized partially, the surface Patricia, the performance, but not the Patricia who had stood in a cul-de-sac watching my property being demolished. Patricia had the right to speak at her own sentencing, and she did. She stood, turned to face the judge, and read from a prepared statement in a clear, controlled voice. She regretted the harm that had been done to the Mercer family, She acknowledged that she had exceeded her authority as HOA president. She expressed remorse for the destruction of the bridge, and she stated that she had learned from the experience and hoped to demonstrate that through her future conduct. She did not say she was wrong. She said she regretted harm and exceeded authority and hoped to demonstrate learning. She said the words of accountability without the substance of accountability, and I watched the judge's face while she spoke and thought, that judge is doing the same analysis I am, counting what's present and what's absent in those careful sentences. The judge, a woman named the Honorable Diane Okafor, no relation to Gary as far as I know, listened to Patricia's statement with complete attentiveness and then was silent for a moment before she spoke, and when she spoke she did it in the measured, precise cadence of someone who has thought carefully about what they're about to say and intends every word. "Ms. Weston," she said, "the court has reviewed the sentencing recommendation, the evidence presented in the preliminary hearing, the forensic audit findings, the documentation submitted by the victim, and the statement you have made here today. I want to address several things directly. First," she said, "the Alford plea you have entered means you have not admitted guilt, and the court respects that procedural right. However, I want to be clear about what the evidence shows because the sentencing decision must be made in full view of the facts as documented. The camera footage in this case shows the destruction of private property on private land without authorization from the property owner. That is unambiguous. Second," she continued, "the structure that was destroyed had been filed for historical preservation review at the time of its destruction and has since received full designation as a locally significant historical structure. The retroactivity of that designation does not change the legal significance of the destruction. What was destroyed was irreplaceable in the original form, and that loss is permanent regardless of what has been rebuilt. Third," she said, and she paused here in a way that made the gallery still, "I have reviewed the forensic audit findings in detail, and I want to note for the record that the financial misconduct documented in that audit is not before this court in this proceeding, but it is part of the context in which this sentencing occurs, and it bears on the court's assessment of the nature and pattern of the conduct. Ms. Weston," Judge Okafor said, "the community you led trusted you with significant authority and significant resources. The evidence indicates that you used both in ways that served your own purposes rather than the community's, and that when a homeowner asserted his legal rights, you responded by destroying his property. That is not a mistake. That is a choice, and choices like that warrant consequences that reflect their seriousness." She sentenced Patricia to 30 days of house arrest, 3 years of supervised probation, a $35,000 fine, $10,000 above the prosecution's recommendation, 250 hours of community service with specific restrictions on any service involving financial management, and the permanent prohibition on serving in any fiduciary HOA role in Virginia, a prohibition, the judge noted, that was not punitive in the traditional sense but simply a reflection of what the evidence suggests about Ms. Weston's fitness for such positions. The $35,000 fine was the part that surprised Patricia's attorneys. I could see it in the brief exchange they had at the defense table, the rapid, quiet consultation, and I thought, "Good, something surprised you. Something landed outside the calculations you made, because that is what accountability feels like when it's functioning, when the consequence exceeds the plan the person made for absorbing it." Patricia received the sentence standing, without visible reaction. She had trained herself over 9 years to receive difficult information without letting it show, and she signed the required documents at the defense table and then turned and walked out of the courtroom with her attorneys in the same formation they'd arrived in, and the door closed behind her and the room breathed. Sandra Chun was crying quietly in the third row, not loud, just tears, the tears of someone who had been on the inside of 9 years of that operation and had hated herself for some of her compliance and was now witnessing the end of it, and Phil Rutherford put his hand on her shoulder and said nothing, which was exactly right. Gary came and sat next to me as people began filing out, and he said, 9 years, for the second time, and I said, yeah. And we sat there for a minute in the emptying gallery before getting up to leave, and I thought about Arthur Keene building a bridge in 1991 that was supposed to last 100 years, and about his son rebuilding it 32 years later, and about what stands and what falls and what can be restored. Marcus found me in the corridor and we shook hands, and he said, "That was the right outcome, Dan." I agreed. He said, "The fine being higher than recommended is the judge telling us she saw exactly what this was." I agreed with that too. We walked out together into the May afternoon, and the air outside the courthouse was warm and smelled like cut grass, ordinary Northern Virginia spring, and it was very good to be outside. I texted Claire from the parking lot. "It's done. She got probation, a big fine, and is permanently banned from HOA roles. Coming home." Claire texted back in under 30 seconds. "Pick up flowers. We're celebrating." I picked up flowers. We ate dinner that night. All four of us, pasta and garlic bread, the particular Italian-American dinner of family occasions. And I told the kids, in general terms, that the situation with the bridge had reached its conclusion and that things were going to be calmer now. And Lily said, "Finally," in the tone of a 10-year-old who has absorbed more ambient parental stress than she's ever let on. And Ben said, "Can we walk over the new bridge after dinner?" And I said yes. We walked over it as a family in the May evening. All four of us, single file, the cedar planks solid under our feet, the ironwork railings smooth and cold to the touch, the creek running below with the small sound it makes when the spring water is up, and on the far bank we turned and looked back at our house, framed in the spring trees, lights on in the kitchen, and Claire took my hand and we stood there for a while. In the weeks after sentencing, something happened in the neighborhood that I had not anticipated and that moved me more than anything in the legal proceedings. Neighbors who had been targets of Patricia's enforcement regime started talking to each other, openly and without the careful circumspection that had characterized every HOA conversation for years. They started organizing informally a kind of mutual support network for people who had issues with the new board or questions about their rights, and they asked me to be part of it, which I was. It was not formal, it was not organized with any structure. Just neighbors sharing information, asking questions, occasionally pooling knowledge about legal resources, and it was, I realized, exactly what Patricia's operation had been designed to prevent. People talking to each other, comparing notes, building the collective awareness that makes individual manipulation impossible. Gary Okafor, who had been fighting Patricia longer than anyone else in the community, was the natural center of that network. He had the history, the credibility, and the particular gift of making people feel their grievances were worth taking seriously, which is rarer than it should be and more valuable than most things I can think of. The new HOA board, under interim President Sanderchin, conducted its first fully transparent annual financial review in June. Every line item publicly posted, every vendor contract available for member inspection, every board vote recorded and distributed in complete minutes within 72 hours, and the attendance at the meeting where those results were presented was the highest in Maplewood Ridge HOA history. I know that because Meredith Cole, who had become the new board's financial records chair, mentioned it while presenting the audit summary. She noted it with a quiet pride that I thought she was entirely entitled to, given that she had spent 2 years preserving the evidence that made any of this possible. The Virginia Department of Housing and Community Development completed its regulatory investigation in June and issued findings that included a formal reprimand of the Maplewood Ridge HOA as an organization for the years of unenforceable rule enforcement and the financial irregularities, along with a set of compliance requirements for the new board, requirements that the new board had, in most cases, already implemented. The regulatory finding was less dramatic than the criminal sentencing, less cinematic, but I thought it was in some ways the more important outcome, because it meant that the pattern of conduct was documented not just in civil and criminal proceedings but in the administrative record of the state agency responsible for overseeing community associations, which meant it would be visible to anyone who looked and would matter if Patricia or anyone like her tried anything similar elsewhere. The Commonwealth Attorney's Office, in a letter to Marcus, confirmed that the financial misconduct documented in the audit, particularly the payments to Crestview Property Solutions and the transfer to the landscaping company account, remained under active investigation and that charges might be forthcoming depending on the outcome of that review, which was not something I was directing or managing, just something that was proceeding in the background of the rest of my life. I don't know what happened with that investigation. I know it was ongoing as of the summer. I know Patricia had retained attorneys for it. What I know most clearly is that it was no longer my fight. The legal system was doing what the legal system does, and I had returned to doing what I do, which is teaching and being a father and walking across my new bridge in the evenings. Dr. Parr contacted me in July to say that Arthur Keene's 4 surviving bridges in Northern Virginia were all in the process of being formally inventoried by the Fairfax County Historic Preservation Commission, prompted by the designation of the Keene Bridge, which meant that the destruction Patricia had ordered had inadvertently secured the preservation of Arthur Keene's legacy across the whole region. I think about that sometimes, how destruction can sometimes catalyze protection, how the effort to eliminate something can draw attention to its significance in ways that quiet preservation never could, and I don't draw any comfortable lessons from it because the bridge that was destroyed was irreplaceable in its original form, and William's reconstruction, as beautiful as it is a new thing, not the old one, and both things are true. William Keene came back in August to walk the new bridge with me. He does this periodically, checking for settling, for any early signs of wear, for the way the cedar is acclimating to its environment, and we stood on the bridge together in the August heat and he said, "She's doing well." The way you'd say it about a living thing, which felt exactly right for a structure made of cedar and iron and craft and time. I asked him if he'd been following the legal proceedings. He said he'd read about the sentencing in the paper. I asked what he thought. He said, "I think she should have to walk across this bridge once a year for the rest of her life." I laughed. Not a polite laugh, but a genuine one, the kind that comes from somewhere unexpected, and he smiled and we walked back to the yard. The school year started in September, and I was teaching a unit on property rights in early American history, land disputes, the legal frameworks that communities build to manage competing interests, the history of what happens when those frameworks are captured by the people they're supposed to constrain, and I was a better teacher for what I'd lived through, not because it made me more theoretical but because it made me more concrete. I told my students at the start of that unit that I had spent the previous year in a property rights dispute, that it had involved lawyers and cameras and a criminal case and a bridge, and that everything we were going to study about how communities govern themselves and protect individual rights was directly relevant to things that were happening right now, in neighborhoods just like theirs, which got their attention in a way that opening a textbook did not. Several parents emailed me after that class. Not complaining but wanting to know more, asking about HOA rights, HOA reform, what homeowners could do if they were in situations like the one I described. And I answered every email, directed people to the Virginia HOA, mentioned Marcus's contact information for those who needed actual legal advice, and spent more hours on that correspondence than I had anticipated. Marcus, when I told him about the emails, laughed and said, "Dan, you have accidentally become a community organizer." I said I was a high school history teacher who had gotten into a fight with his HOA and won. He said, "Yeah, but now you're telling people about it and that's the same thing." I thought about that for a while and decided he was probably right. In October, Sandra Chun was formally elected HOA president of Maplewood Ridge by a community vote. Not appointed, not installed by procedural maneuvering, but elected in a proper ballot process with 3 candidates and 58% turnout, which was, according to Meredith Cole, the highest HOA election turnout in the community's history. Sandra called me after the results were announced to say thank you, and I told her she didn't need to thank me, that the work she'd done on the board for 3 years under impossible conditions had made everything else possible, that her preserved dissenting memo and her willingness to call the audit and the removal vote had been the inflection points, not anything I'd done. She said, "We did it together, Dan, And I said, "Yeah, we did." And I meant it because accountability is always collective. It requires someone to expose the problem, someone to document it, someone to vote on it, someone to prosecute it, someone to adjudicate it, and every one of those someone's matters, and the absence of any one of them would have changed the outcome. Patricia Weston, as far as I know, has not appeared at any community event in Maplewood Ridge since the sentencing. She continues to live in the neighborhood, continues to maintain her front yard with seasonal flowers that change every 8 weeks, which I see when I drive out in the morning, a detail I note without feeling anything in particular about it. I am aware that she has appealed aspects of the sentencing. Her attorneys filed for a modification on the fine amount, which Marcus tells me is unlikely to succeed but which is her right to attempt, and I am aware that the financial investigation continues, and I am aware that these things are proceeding on their own timeline independent of my attention, and I have decided that my attention belongs elsewhere. What I have decided my attention belongs to: my family, my students, the bridge at the back of my property, the creek trail that my neighbors cross in the mornings on their way to the greenway, the neighborhood that is slowly, tentatively becoming something different from what it was. Less guarded, more open, the way a place gets when it stops being run by fear. Gary stopped me on the trail one Saturday morning in November. He was coming back from a walk. I was heading out, and he said, "The new bridge looks good, man." And I said, "Yeah, it does." And he said, "Your family doing okay?" And I said, "Yeah, we are." And we stood there for a minute in the November air and then went our separate ways, and it was exactly what it should have been. Ordinary, easy, the conversation of two neighbors in a neighborhood that was working. I walked out to the bridge that morning after Gary and I parted, and I stood on it in the November light. The cedar gleaming in the low winter sun, the ironwork catching the light the way new metal does, and I thought about everything that had happened to get to this exact spot on this exact bridge, the 16 months of legal combat and documentation and patience and sleepless nights and depositions and hearings. And I thought about Meredith Cole with her 11 binders, and William Keene with his father's blueprints, and Sandra Chun with her dissenting memo, and Phil Rutherford saying quietly, "Look at the maintenance reserve," and Teresa Walsh calling to tell me what she'd overheard at a dinner party, and Frank DeLuca watching from his yard, and Gary with his manila folder of 2 years of violations, and Agent Holloway with her careful, layered questions. None of it had been done alone. Every piece of it had required someone willing to say, in some form or another, "This isn't right, this matters, I will stand for this," and those people had shown up, one by one, in the way that they do when a community is still alive enough to recognize injustice and decide that recognition requires action. I thought about Arthur Keene building his bridge in 1991 and his son building it again 32 years later, and I thought about the way things persist when people decide they're worth persisting, and I thought about my students and the unit on property rights and communities, and I stood on the Keene Bridge in November light and felt, simply and completely, that we were home. In December, I received a card in the mail, handwritten, no return address, postmarked from a zip code in Northern Virginia I didn't recognize, that said simply, "Mr. Mercer, I saw what you did and what it took. You made it possible for someone else to do the same thing. Thank you." No name. I don't know who sent it, kept it. Marcus sent me a text in late December. Financial investigation update. Charges filed. 3 counts. Not sharing more until official. But it's happening. I sent him back, "Thank you for everything." He sent, "Thank you for being the kind of client who actually keeps records." I laughed alone in my kitchen at 11 p.m. on a Thursday in December and then went to bed. The new year arrived with the particular quiet that January brings to Northern Virginia. Cold, still, the neighborhood hunkered down and private, and I walked out to the bridge. On New Year's morning alone, before anyone else in the house was up, in my coat and hiking boots, carrying coffee, and I crossed it and stood on the far bank in the dawn light. The creek was frozen at the edges and running dark in the center, the sound of it muffled by the cold, and the cedar of the new bridge was pale in the winter light, paler than it would be in summer, and the iron railings were cold under my glove. Not uncomfortably cold, just present, solid, the satisfying coldness of well-made metal on a January morning. I thought about the first morning, the coffee cup in my hand, the bulldozer, the crack of the first plank, Patricia in the cream blazer, and I thought about the last time I had been genuinely afraid in this whole process, which was the moment I pulled up to my street and saw the skid steer already positioned, already beginning, and the realization had hit me that I was too late to stop the destruction but not too late to document it. And I thought, the documentation was what mattered. Not the anger, not the legal sophistication, not any particular cleverness. The fact that I had been there with the phone up, that the cameras were running, that the engineer's report existed, that Sandra Chun had kept her dissenting memo, that Meredith Cole had kept 11 binders. That is what the whole thing had stood on, the accumulated, methodical, unglamorous work of bearing witness. There is a lesson in that about how accountability actually works in communities and in courts and in history. It does not come from the dramatic moment, it comes from the thousand small decisions to document and preserve and not let things slide, to say this is not right in writing with a date attached, to keep the receipt, to file the complaint, to note the timestamp. I am a history teacher. I know that the past is made of documents, that what survives the distance is what was written down, what was witnessed, what was deliberately preserved by someone who understood that memory alone was not enough. I had applied that knowledge to my own life and it had worked, and that was not a comfortable thing to be proud of, but it was something. The walk back across the bridge in the January dawn was short, 15 steps, maybe 18, and the cedar held solid under my boots and the ironwork was steady in my hands. And the new Keene Bridge did what Arthur Keene's bridge had done for 32 years. It connected one bank to the other, simply and without drama, as a well-built thing does. I went back inside, refilled my coffee, and stood at the kitchen window watching the light come up over the backyard. The bridge visible in the growing morning, the creek running quietly beyond it, the neighborhood waking slowly around. Us, the ordinary beginning of an ordinary day in a house I love in a neighborhood that is healing, and my family asleep upstairs, and the work ahead of me. Teaching, being a father, crossing the bridge in the evenings, paying attention. That is enough. That has always been enough. The fight was never for more than that, for the ordinary life of a family in a house they saved 11 years to buy, with a yard and a trail and a bridge at the edge of the property, with the right to be left alone to live it. And that is what we have and what Patricia Weston could not take even when she sent the bulldozer, because you can destroy a bridge but you cannot destroy what it stands for if the people who depend on it decide to rebuild. And we rebuilt it. William Keene rebuilt it. The community rebuilt itself. And the bridge stands in the January light on Creekside Lane, Maplewood Ridge, Virginia, cedar and iron and craft and time, the second bridge and the better one. Evidence that some things, destroyed deliberately with planning and forethought, can be restored not only to what they were but to what they were always supposed to become. The financial charges Marcus had mentioned were formally announced in February. 3 counts of embezzlement against Patricia Weston. 1 count of breach of fiduciary duty, based on the forensic audit findings regarding the Crestview payments and the transfers to her husband's landscaping account. A separate legal proceeding that I was named as a complainant in but that Marcus was handling with barely any involvement required from me. The HOA, under Sandra's leadership, filed a civil recovery action against Patricia personally for the $87,000 in unverified Crestview payments, seeking restitution to the community's maintenance reserve. A lawsuit that would take time to resolve but that Sandra described to me as the most important piece, because it gets the money back to the people it was taken from, which was the clearest statement of purpose I'd heard in the whole proceeding. Terraform Construction was subsequently denied renewal of its Virginia contracting license due to the operating violations and the permit issues, which meant the company effectively ceased to operate in the state. I learned this from a brief entry in the county's public regulatory notices and noted it without ceremony, because it was simply what should happen when a company ignores trespass concerns and demolishes private property under an invalid contract. Several neighbors who had paid the unenforceable fines over the years, fines that the new board was refunding, used those refund amounts to make small donations to the Fairfax County Historical Preservation Trust in honor of Arthur Keene, which Sandra announced at the spring community meeting in a moment that produced the particular silence of a room that has collectively understood something important. I received a letter from the Fairfax County Historic Preservation Commission in March confirming that the Keene Bridge at 1847 Creekside Lane had been formally entered into the county's official historic structures register, a permanent designation, recorded and maintained, which means that any future alteration to the bridge, by any owner of that property in perpetuity, requires county review and approval before any work may proceed. Claire framed the designation letter and hung it in the kitchen. Lily asked what it said, and I told her it said the bridge was important and had to be protected. She said, "Because of what happened?" And I said, "Yes, partly because of that." She said, "That's actually kind of good then," and went back to her homework, and I thought about that for a long time. The 10-year-old's unsentimental accounting of how something painful can produce something that lasts. On a Saturday in May, 1 year and 2 months after the morning Patricia sent the bulldozer, I crossed the Keene Bridge with Claire and both kids on the way to the Greenway Trail, all 4 of us, and as we stepped onto the cedar planks and I felt the solid give of Goodwood underfoot and the cool iron railing in my hand, I thought, she tried to take this from us and she paid for a better one, and she will never set foot on a board again, and we are crossing it together on a Saturday morning in the spring. And this is what winning looks like, not dramatic, not loud, just this. Patricia Weston's cream blazer still appears at the end of her driveway on collection days. Her seasonal flowers still change every 8 weeks. She is still here, still our neighbor, in the way that people remain present in communities they have damaged but not destroyed. Diminished, constrained, stripped of the authority she mistook for identity. And that is consequence enough. And more than enough, and it is what justice looks like when it works the way it's supposed to. Not obliteration, just proportion, just the weight of what you chose pressing back against you in permanent, documented, undeniable form. The bridge stands. The Keene Bridge stands in cedar and iron and the craft of a son honoring his father, on a creek bank in Maplewood Ridge, Virginia, open to the neighborhood in the mornings, open to my family in the evenings, designated and protected and documented and real, and every time I cross it I think about Arthur Keene building something in 1991 that was supposed to last 100 years, and I think Patricia Weston tried to stop it at 32, and instead she guaranteed the next 100, and that is the most complete and satisfying accounting of this whole story that I know how to give.